What is bail? May everybody post bail? These questions are the common ones raised by public whenever one is apprehended for the commission of a crime. But answers are sometimes not concrete enough to illuminate them. Bail is one of the basic rights as a Filipino. What law governs bail in the Philippines? Bail is guaranteed by Section 13, Article 3 of the 1987 Philippine Constitution, and it states, all persons except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong shall before conviction be bailable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. In People of the Philippines versus Manuel Escobar, GR number 214300, July 26, 2017, the Supreme Court unequivocally stated that the right to bail is cognate to the fundamental right to be presumed innocent. Procedurally, Rule 114 of the 2000 Revised Rules of Criminal Procedure governs the application for bail. When does one consider to be in custody of the law? When someone is arrested, it means that a person is placed in custody in order that he may be bound to answer for the commission of an offense. As a basic rule in criminal procedure, the arresting officer has the duty to deliver the arrested person to the nearest police station or jail without unnecessary delay. What are the forms of bail or bond? Bail is not always in cash. It may be given in the form of corporate surety, property bond, cash deposit, or recognizance. The choice lies with the applicant. Corporate bond, one issued by a corporation licensed to provide bail, subscribed jointly by the accused and an officer duly authorized by its board of directors. Property bond, an undertaking constituted as a line on the real property given as security for the amount of the bond. Recognizance, an obligation of record entered into usually by the responsible members of the community before some court or magistrate duly authorized to take it, with the condition to do some particular act, the most usual act being to assure the appearance of the accused for trial. And lastly, cash deposit, the money deposited by the accused or any person acting on his behalf with the nearest collector of internal revenue or provincial, city, or municipal treasurer. Considered as bail, it may be applied to the payment of any fees and cost, and the excess, if any, shall be returned to the accused or to whoever made the deposit. What are the conditions of bail? Under the rules, all kinds of bail are subject to the following conditions, which shall be followed, otherwise the bail will be forfeited. The undertaking shall be effective upon approval, and unless cancelled, shall remain in force at all stages of the case. Number 2, the accused shall appear before the proper court whenever required by the court or by the rules of court. Number 3, the failure of the accused to appear at the trial without justification and despite due notice shall be deemed a waiver of his right to be present thereat. And lastly, the bondsman shall surrender the accused to the court for execution of the final judgment. When is bail a matter of right? Section 4 of Rule 114 states that all persons in custody shall be admitted to bail as a matter of right. Number 1, before or after conviction by the Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court. Number 2, before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment, and before judgment of conviction by the Regional Trial Court of an offense punishable by death, reclusion perpetua, or life imprisonment and evidence of guilt is not strong. When is bail a matter of discretion? Before judgment of conviction by the Regional Trial Court of an offense punishable by death, reclusion perpetua, or life imprisonment, and the evidence of guilt is strong. after judgment of conviction by the regional trial court, and the penalty imposed is imprisonment exceeding 6 years but less than death, reclusion perpetua or life imprisonment, and any of the following bail negating circumstances is present.
If you're in fact considered a flight risk, meaning the court has reason to believe you may try to flee the country, or if you're considered a serious violent threat to others, the court may flat out deny bail, or simply dramatically increase the amount. Hopefully, if you've been forced to remortgage your house to post bail, you may be financially motivated to actually show up to court. Some individuals, though, especially those facing multiple murder charges or terrorism charges, are denied bail completely and may never post it, thus remaining in police custody until the end of their trial.
Upon finality of judgment of conviction, unless the accused file an application for probation, who has the burden of proof to show that evidence of guilt is strong? At the hearing of an application for bail filed by a person who is in custody for the commission of an offense punishable by death, reclusion perpetua, or life imprisonment, the prosecution has the burden of showing that evidence of guilt is strong. How much is the bail? The judge who issued the warrant or granted the application for bail shall fix a reasonable amount of bail, taking into consideration several factors. However, excessive bail shall not be required as enshrined in the Bill of Rights. Normally, the judge who issued the warrant or granted the application for bail will take into consideration the bail recommended in the Bail Bond Guide issued by the Department of Justice. This, however, is not binding but greatly persuasive, as ultimately the constitutional duty of granting bail lies with the judge. Furthermore, the accused may file a motion to reduce bail. If accused is acquitted, he gets back what he deposited, unless forfeited for violating the conditions of the bail.